Very good morning, friends. At the outset, let me welcome each and every one of you for the fast track webinar series for IBBA Limited Insolvency exam. This is for 2021 syllabus. From another 28 days, March 1st onwards, we are going to witness 2022 syllabus. And you have another 28 plus 1, 29 days for your present syllabus examination. We are also going to do a insolvency pinnacle session, which will be on February 5th and 6th evening, 7 to 9 p.m., which will be focused towards the case laws and the case studies. So don't miss this particular program. Friends, today's topic will be quite interesting. And I'm going to focus on the amendments made on these three regulations. What are those regulations? IBBI Information Utility Regulation, IBBI Insolvency Professional Regulation, IBBI Model Bylaws and General Body of IPA Regulation, and IBBI Insolvency Professional Agency Regulations. There has been quite substantial changes has been made between 30th June 2019 to 31st December 2020. And these are the regulations where the changes has been brought out. And I'll be taking you through these important changes and also the relevant questions based on this. Let me first take you to the IPA regulation 52C. I have with me here the IPA regulation 2016, which is amended up to 23/7/2019. This is 23/7/2019. And I also have the IBBA Model Bylaws and Governing Board of Insolvency Professional Agency Regulation, amended up to 24/4/2020. That is the regulation applicable for your 2021 syllabus examination. I also have with me the IP regulations, which is amended up to 1st of July 2020, which is applicable for your examination. And the Information Utility Regulation, which is amended up to 13th of November 2020. Please ensure to have these four regulations with you. No soft copy. Maybe since it is a webinar, I am using a soft copy to connect these amendments. But when you study, take a printout and have it in a binded format. Use a yellow color highlighter or a pencil and try to take notes so that you get a grip on all these amendments. Let me first take you to, there is only one change with respect to insolvency professional agencies. So I'll take you to regulation number 5, sub-regulation 2 and C. This is the change that has been brought out. Remember, guys, who are the insolvency professional agency? We have three: ICAI, IPA. It's called triple IP ICAI, ICSI IPA, and ICMAI IPA. So these are the only three insolvency professional agencies. And any person who wish to become an insolvency professional, they want to get enrolled with IBBI, they have to first become member with any one of the IPA, which is mandatory. You have to complete the 50-hour PREC training program, the pre-registration education course training program. And this regulation has been brought as a change to their annual fees. Pay an annual fee of 5 lakh rupees to the board within 15 days from the date of commencement of the financial year. So what is the meaning? 31st March 2022 is the last date. Commencement of the next financial year is 1st April 2022. From there, 15 days means 15th of April 2022. So every year they have to pay 5 lakh annual fees. This is point number 1. Point number 2, this 15 days if you cross, you have to pay an interest, and the interest will be 12% per annum. Please remember, provided without prejudice, the board may take as permissible under the code any delay in payment of fee shall attract simple interest at 12% per annum till paid. Most important. And I wish to share with you one more additional point. Provided no annual fee is payable in which an IPA is granted registration or renewal as the case may be. So, renewal fee is different and annual fee is different. Maybe first time when they are granted registration during 21-22, let us presume, they need not pay the annual fee because already registration fee is paid. And every once in 5 years, they have to do the renewal. When they pay the renewal fee, they need not pay the annual fee. That means between your renewal and the next renewal, you have 4 years. So for every year, you have to pay the annual fee. This is the meaning you have to understand here. Now, let me share with you one question. Every insolvency professional agency shall pay an annual fee of 5 lakh rupees to the board. Very good. Within how many days from the date of commencement of financial year? 30 days, 45 days, 60 days, or 15 days? It is 15 days. So it is 1A for your kind information. Okay. So within 15 days from the date of commencement. Good. Now let me take you to the Insolvency Professional Regulation. 13A CA, 13A CB, Code of Conduct for Insolvency Professional will be in schedule of the Insolvency Professional Agency, and 21A, 21AA, 72A Proviso, 7A, 10.1, 11.8BA, 12.1A, 13.2B Proviso, 13.2C Proviso, and Information Utility. These 5 changes. Let me take you one by one. Now, first I will take you to this MBL and GB of IPA because there is only one provision. Okay. Please look at this. Model Bylaws and Governing Board of Insolvency Professional Agencies. I'll take you to Regulation 5, Sub-Regulation 8. This is a very, very important change they have brought. Now, why I am bringing this particular amendment to you is, please look at this change they have brought here. An individual may serve as an independent director in the board of the Insolvency Professional Agency. And I want to bring to your kind attention that the independent directors under the Companies Act, if you go through, there also the age is 75 for your information. Okay, so why they have, previous to this, it was not 75, it was only 70. Okay, so they have changed this to 75. So an individual may serve as an independent director. The word independent director itself only refers to Insolvency Professional Agency. Okay, for a maximum of 2 terms of 3 years each. What is that? 2 terms of 3 years each means what? Every term 3 years. And they can be further, one term they can be extended for one more term. So 3 years plus 3 years, so 6 years. So maximum of 2 terms. 2 terms, 3 years each, are part thereof. What is the meaning? If somebody is brought in as an independent director, okay, instead of in lieu of another independent director, maybe by otherwise by rotation, by death, there is another person who has been appointed in that particular place. Let us take an example. So he will only hold the position for maybe 1.5 years or 2 years, whatever the time. So that will be counted as one term. So this is in sync with the independent director prescription, the independent director's regulation, which is prescribed in the LODR, SEBI LODR, and also under the Companies Act. So Companies Act and LODR, and in sync with that, they have amended Regulation 58. Okay, this is very important. Okay, now I'll just take you to one particular question in this. Maybe I'll take you to 25. An individual may serve, okay, as an independent director for a maximum period of 3 or 5 years means 15 years. Wrong. And 2 or 5 years means 2 into 5, which will be 10 years. That is also wrong. 3 terms of 2 years each, that is 3 into 2, 6 years. 6 years is correct. But it is not 3 terms of 2 years each. It is 2 terms of 3 years each. So please understand this. So it is 25B for your kind information. Okay. Now, come to this. Now, I want to bring your kind attention to schedule number 12A2E and 12A for authorization for assignment, 7A authorization for assignment, this 12A2E and 9.7. Both are in green color. Now, why both are in green color? Because it is comparable. Similarly, 12A of the MBL and governing body of IPA and IP7A both are comparable. So one by one I will come, which is very, very important. Okay. So now what I have completed is 5.2C I have completed. Now the 5.8 I have completed. Okay, good. Now let me take you to a schedule, which is very important. Okay. So please come to the schedule. The schedule is the model bylaw code format is given. Model bylaw code format. So whether it is triple IP ICAI or ICMA IPA or ICSA IPA, all the three they have will have this model bylaw format. Only the wherever the underlining is there, that alone will be filled up. So it's very, very strict code. Okay, so you can't amend just like that. So of course, if you want to amend the model bylaw, there is a procedure for it. Okay, you have to go back and again get the approval, and all this stuff is there. Now, where the change has been brought, 4.1A. So the para number 4. Okay. And I wish to bring your kind attention to certain changes they have brought. 4.1 small a, assignment and authorization for assignment. Okay. So these two are new change which has been introduced. Now, very important. So what is this 4.1A? Assignment means now you are an insolvency professional, you qualify the examination, you complete the 50-hour PREC training program, you apply for the license, you get the license. Once you get the license as an insolvency professional, can you take any assignment? Okay. Remember, guys, qualifying insolvency professional examination is step 1. Getting license is step 2. And most important, you must get AFA to get the assignment. Because you are a independent legal professional. Insolvency professional is a legal profession. Please understand. So therefore, they are bringing innumerable conditions, constraints, so that your independence cannot be questioned. Okay, and people don't use the independence or flout their independence for the benefit of themselves. So that is very important. So assignment here means an IP can take avatar. Or how many avatars he can take? He can take 5 avatars. Okay. So Panchatantiram. What are the Panchatantiram? IRP, interim resolution professional, is one assignment. Resolution professional is another assignment. Liquidator is a third assignment. Bankruptcy trustee is a fourth assignment. And you can be an authorized representative representing a group. For example, you are an insolvency professional representing a group of home buyers. Maybe there are some 500 home buyers. For every 100 home buyers, there can be one representative can be appointed, and you will be a representative. So an IP can be an authorized representative. So look at the 5 different avatars you take. Okay. And for your information, this resolution professional, again you have a sub avatar. Resolution professional for a CIRP, resolution professional for an IRP. Okay. Individual resolution process. Okay. Corporate insolvency resolution process, individual resolution process, individual insolvency resolution process. So there the RP can take roles like that also. So this assignment is a very important definition they have brought. AFA, this is very, very important because this definition, okay, I will also take you to IP. Because in IP also very similar definition. This 41A and 132CA, 41A and 132CB, there will be similarity. Similar in IP also 21A, 21AA, there will be similarity. I'll come one by one. I'll come. So we are now in the schedule of the model, bylaw, and general body of the insolvency professional agency. Okay. Now, what is AFA? Authorization to take an assignment. Now, who will authorize? This is the question. See, examination is conducted by the IP examination is conducted by the agency appointed by the IBBA. Okay, IBBA only conducts the exam, but agency of the IBBA only conducts the examination. Okay, so it was NISM. Okay, when I used to write examination, it was NISM. Okay, so now also it is NISM one. Now, authorization for assignment. So once you clear the examination, you need to enroll with the IPA, get license from IBBA. Then what for IPA is there? This is the fundamental question. So IPA was only a education institution. So they are not a tier 2 regulator. So how to bring a tier 2, how to make them a regulator? By bringing this concept called authorization. So who will give authorization now? License will be given by IBBI, but authorization for assignment will be given by the IPA. So IPA only will give clearance. Okay, there is no disciplinary proceeding. He has paid the fees timely. He has cleared all the CPE programs. This continuing professional education is very important. If you have not done your continuing professional education, you will not be eligible. You will not be given authorization. If you are not given authorization, you will not be given assignment. Matter over. That's all. So authorization to undertake an assignment issued by IPA, very important. To an IP. Who gives IPA? To whom IP? Both of them are under IBBI. IBBA is a mother. So you have an elder brother, IPA. The younger sister or younger brother is IP. Okay. Who is its professional member? Professional member. Now I am Gopal Krishna Raju. I am the professional member of Triple IP ICAI. Okay. So Triple IP ICAI means I should get the AFA from whom? I should get the AFA from Triple IP ICAI. Okay. Good. So this is very important for your information. So this is your 41A and 41AA. Now I'll take you to IP parallel. Okay, this is your IP regulation. In IP regulation also, look at 21A, 21AA. 41A, 41A schedule, 21A, 21AA. Here also, they included assignment and authorization for assignment. So I will not, so it is repeat. It is repeat. So this is IP regulation. That is schedule of the model bylaws and general body of the IP regulation. So note down this, guys. So 41A as well as 21A, both are same. So what is 21A? Assignment. Same repeat. What is authorization for assignment? Same repeat. So 41AA and your 21AA, both are same. 41AA of the schedule of the MBL GB IPA and 21AA of the IP, both are same. Clear? Good. Now come to the very important change now. Again go to GB. I'll take you to GB. I'll take you to 12.1 FA. Very important. Very, very important. So please pay your kind attention, guys. Okay, 12(1) FA. This is 12 Register of Professional Members FA. Now, since authorization for appointment, authorization for assignment, AFA, has been defined, they are included between F and G. Okay. In your Register of Professional Members, IBBI will maintain this. Date of issue of AFA. Date of renewal of AFA. Every year you have to renew AFA. When it was suspended, when it was revoked, suspension will be cancelled. Cancellation of AFA, acceptance or surrender of AFA. You can even say, no, I'm going abroad for 3 months. So please suspend my surrender. You will surrender the AFA. Okay, not suspend, you will surrender the AFA. You will say, I will call it as please issue. Okay, please renew or please issue the authorization once I'm back. So that temporary withdrawal of AFA is also possible, and authorization number. Okay, you can go to the IPA website and find out my name and who are all have been issued authorization for assignment. Every year you have to do this, and if you have to do this, you have to comply with the CP requirement. You have to comply with the CP requirement. That is most important. Okay, so you are 12(1) FA. Okay, this is this who has to maintain? This has to be maintained by the Insolvency Professional Agency in the Register of Professional Member. Okay, so you are an insolvency professional under IBBI. You are a professional member of the IPA. Now I will take you to the 7(2) Proviso of the IP. This is the IP regulation. 7(2) Proviso. So regulation 7(2) Proviso. This is very important change they have brought up. On this also I will do 1 or 2 questions. Okay. Now you have to pay to the board 10,000 rupees every 5 years after the year in which the certificate is granted, and such a fee shall be paid on or before 30th of April of the year in which it falls due. Okay. So every 5 years you have to pay to the board a fee of 10,000 rupees. Okay. Now, apart from this, please look at this. Pay to the board a fee calculated at the rate of, now board means what? The IBBI. Please look at this. The definition, they have made it very clear. So our board, you can go to the code itself because this is coming under the code. Okay. So pay to the board a fee calculated at 0.25% of the professional fee. And somebody asked me, I don't have assignment I don't have AFA, so therefore I don't have an assignment. Since I don't have an assignment and AFA, I am not appointed elsewhere. I am not earning any professional fees. Okay. So this professional fee is earned for the services rendered by him as an insolvency professional, as an IP. Okay. So in the capacity of any assignment, that 5 avatar or Panchatantiram. Okay. What is that? IRP, RP, liquidator, bankruptcy trustee, or authorized representative. So if you get any fee, on that you have to give a share. Okay. 0.25% of that fee you have to pay to the board on or before 30th of April every year. Now, this was only relaxed because of the pandemic. In the pandemic period, that instead of 30th April, they made it as 30th June. Okay, that was only for the pandemic period alone. That 1920 financial year, you have to pay before 30th April because 30th April 2020 was a lockdown throughout the country. So therefore, they inserted this proviso 7. On 28th April 2020, they inserted this proviso. So please note down, this can be an exam question. Okay, whatever I'm discussing is an exam question. Okay. So now what I will do, I'll take you to one particular question here. Please look at this question, guys. Okay, maybe this question you look at it. An insolvency professional shall pay to the board a fee calculated at the rate of 0.1% or 0.25%. So naturally 0.1% is not there. It is 0.25%. So A and C is wrong. So it is only B and D is correct. So 0.25% of the professional fee earned by the services rendered by him in the preceding financial year on or before what date? 31st May or 30th April. Okay. So you have to pay on or before 30th April. Okay. That is 1 month. So that annual renewal fee of IP and all within 15 days. To the board, 0.25% fee you have to pay. To the board means always 30 days. IP to the board always 30 days. IPA to the board is always 15 days. IU to the board is also always 15 days. IPA to the board, IU to the board, fee payment is all 15 days. Okay. So now, only thing they have relaxed is 30th April, they relaxed to 30th June only because of the lockdown, countrywide lockdown. Okay. So 0.25, 30th April, along with the statement in Form E. This particular Form E of the second schedule will give the content of what you have actually, what are the, for each kind of assignment, what is the fee you have done. I'll just show you the Form E also. Please go through this. So this is your form number E. This is your form number E, and this is your form. Please look at it. Services rendered as Panchatantra services. IRP, RP, liquidator, trustee, or other. Other means your authorized representative. Okay. Professional fee as an insolvency professional for the year. You have to give this. Okay. And then you have to, sum is worked out because multiply with 0.25%. You have to use the calculator, work it out, and then pay this fee. Okay. Good. So this is your. So 11th question is D. Answer is D. Now I have completed 2-1A, 2-1AA, 7-2CA Praviso. Okay. Why that Praviso? Praviso is the amendment. Amendment because of the pandemic. Okay. Now I'm taking you to a very important section. Okay, regulation between the model bylaws and general body of IPA and IP, which is 7A. Okay, the 7A, AFA, also your model bylaws 12 capital A. This is your model bylaws. In this, okay. So I'll take you to the schedule number 1. So where is your schedule number 1? I think I'm in schedule number 2. So this is IPA. This is model bylaws. So model bylaws, I'll take you to regulation 12A. Yes, AF. Very, very important point. Okay. Because look at this IP. Right. So let me first complete this 7A and 12A. Because 7A and 12A are exact replica. Okay. First come to 7A. An IP shall not accept or undertake an assignment after 31st December 2019. Please make this point very clear. That means your name should be there in AFA. Unless you hold a valid authorization for what is called valid, it should be up to date. Okay, that means there should not be any surrender, there should not be any suspension. Okay, that is why it's called valid. Maybe you would have got an AFA, but it should be at the time of appointment, it should be valid. Okay, so this is very important. So that IPS also will have a role to play here. And IPS also can collect some fees. And there will be, only because of AFA, the CP becomes very important. And there has been quite a number of changes. I'm telling you guys. You may wonder, okay, what is so much of regulation, so much of regulation? It is one way good. Why? Because this is one subject where continuous updation happens. Now, how to make our insolvency professionals continually updated? By having an yearly AFA, authorization for assignment. You will be surprised. We have close to 4,000 insolvency professionals. 4,000. But how many people are holding AFA? Less than 1,000 only. That means 75% of them, they don't want to take AFA, for your information. So out of 4, 3 are not taking AFA. Only 1 is taking AFA. Very important. So until he holds a valid AFA on the date on such acceptance or commencement of such assignment, as the case may be. Okay. Now come to 12A. This is 12A. The agency, on an application by its professional member, may issue or renew. So they have to make an application. And a professional member will be eligible if he is registered with the board. So that means he should have the license. Fit and proper person. This fit means not physically fit, mentally fit. Okay. Of course, mentally fit, physically fit should be there. Okay. This fit and proper person, there is a 3 criteria for it. Not in employment, very important. Not debarred by the agency or the board. You will be surprised. I used to say, for an insolvency professional, there are 2 spouses. Okay, 2 spouses. One spouse is the IBBI. Okay, the another spouse. Actually, I want to make it very colloquial. Okay, I'll not call it a spouse. I'll call it as 2 mother-in-laws. Okay, sorry for that. There are 2 mother-in-laws. No, not 1 mother-in-law, 2 mother-in-law. Okay, so who are those 2 mother-in-laws? One is your IBBI. Another is your IPA. So 2 mother-in-laws are there. Okay. So look at this. That means you have a disciplinary proceedings by IBBI. You also have a disciplinary proceedings under the Insolvency Professional Agency. That is why I said 2 mother-in-laws. So not debarred by any direction or order of the agency of the board. Has not attained the age of 70. Very important. Very, very important. See, I gave this 75. This 75 is only for independent director in IPA. But for an IP, those who have not crossed 70, okay, those who have crossed 70, AFA not possible. They can only give advisory. They can only be an advisor. And for your information, out of this 4,000 IPAs, minimum 400 IPAs, 10% of the IPAs have crossed 70, for your information. Cross 70. So that means they are not eligible. Straight away, they are not eligible to be appointed. Okay. So now this is one place there is an anomaly. When an independent director in the board of an IPA can be 75 years, they say they want to in sync with the LODR Companies Act. Similarly, this also must be amended to be in sync with the LODR Companies Act and the independent director for an IPA. It should be 75 only. Okay. So please understand the kind of changes that will come. Okay. There will be in 2022, there will be an amendment. So please note down this. So that is your 12A. And no disciplinary proceeding pending against him before the agency or the board. Okay. Then not debarred by any order. No disciplinary proceedings pending. D and F has a difference. D is, there is a direction already given. F is proceedings is pending. If proceeding is pending itself, he is not eligible. So please, and that is why the difference is between 4,000 IPs and less than 1,000 IPs who hold AFA. Applies with requirements as on the date of application with respect to payment of fee to agency and board, filing of disclosures to agency and board, CPE, continuing professional education. See, this is very, very important. So some of the forms you would not have filed at all. If some of the forms you have not filed, they very clearly says your AFA will be rejected. AFA apply rejected. AFA apply rejected. Because that file is not, that particular form is not filed. So there are certain forms you have to file. Maybe if you don't have an assignment, nil. Okay, one nil form you have to file. Of course, now they are giving one more thing. There is no need to file a nil form. So you need to be thorough with it, because every now and then IPAs are also quite, they are very vehemently amending the provisions with respect to compliance by IPs to IPS. So you need to be very careful. and please go to their website to get that updation. Okay, so that is very important for you. So 12A and 7A. So that is your comparison. Okay. Now I'm coming for 13.2CA and 13.2CB. Okay. Come to this, guys. 13. This is the insolvency professional regulation. Okay. In this 13.2CA and 13.2CB. This part we have already seen in the 0.25% of the turnover for the services rendered. We have already seen it. Pay to the board a fee calculated at the rate of 0.25% of the turnover from the services rendered by it in the preceding financial year on or before 30th of April, along with the statement in Form G of the second schedule, provided that the financial year it is 32. So this provision we have already seen. Okay, good. So that is why I am repeating it here. So that is with respect to 13.2CA. Good. We already saw that amendment in 7.2CA provisos. This 7.2CA and 13.2CA. This is 13.2CA and this is your 7.2CA. Got it. Now let me take you. This is your 12.1FA. 12.1FA of IBBI. Okay, what is this? This is your IB. 12.1FA. This is FA. Now 4.1A. That is 4.1A. Now 2.172CA provision. Okay, that I already mentioned. Now 13.2CB. Come to this. So where am I? 13.2CB. Submit to the board by 15th day of October every year a compliance certificate in Form H for the preceding financial year, provided that the IP entity recognized shall submit to the board by 31st December a compliance certificate in Form H for the financial year 18-19. Now, this is very important. Okay. So, one is you have to calculate your fee for the total turnover or for the total professional fees and pay that fees within 30th of April. One relaxation is given to you. That relaxation is for the financial year 19-20. Instead of 30th April, you can pay on 30th June. Clear. So both the regulations I have mentioned. Now this is a compliance certificate in Form H for the preceding. Now this is your Form H, guys. Look at this. This is your Form H. This compliance certificate has to be filed. What is the have been authorized at all times, complied with all the regulations, complied. So you have to give a self-declaration. And if you are an insolvency professional entity, okay, you have time. The time is up to 31st of December. You have to give this particular information. Who are the director, address, DIN, PAN, registration number, insolvency professional membership, shares, whole-time director or not. So none of the directors is the director of another professional entity. So all this you have to give this declaration and give a submission that you have complied all the provisions. At all times complied with clause 8.2G of regulation 12.1 and complied with clause 2B to CA of regulation 13. This is what I'm going to go through now. Okay. So please look at this. 12. Okay. All the provision of 12, 13. I'm going to discuss that. Okay. Please wait. So I'm now in 13.2CB. So look at 13.2CB. This is your regulation number 13.2CB. So submit to the board within 15th day of October. So note down this date, guys. If you are an individual insolvency professional, Form H has to be submitted within 15th of October. If you are an insolvency professional entity, it is 31st of December. Okay. So 31st of December. Okay. So that is the only point. But please remember that an IP entity recognized as on 31st March 2019 shall submit by the board by 31st December a compliance certificate. That is only for 1 year. That 1 year relaxation alone given. Submit to the board 15th of October compliance certificate for the preceding financial year. So this relaxation is only for 1 year, for financial year 18-19. After that, no. Okay. So that means even an insolvency professional entity for the financial year 2021, now 21-22, they have to file it before 15th day of October. So much of compliance, guys. So much of compliance. So that is why the insolvency professional or the insolvency professional entity for uppany fees and all, it should not. There is no negotiation at all. Insolvency professional you want to appoint means whatever fees insolvency professional he charges is final. Is final because this profession demands that. Please understand. This profession demands. So there is no question for negotiation. Such a kind of compliances and the self-declaration that you have complied all the provision has to be given. Please be careful. Now this code of conduct, they have amended 5 areas. Okay, code of conduct, they have amended 5 areas. So here 13.2 CA and 13.2 CB has been done. Now code of conduct, let me take you. So this is your code of conduct, guys. First schedule code of conduct. They amended 5 code. 3A they have amended. They inserted actually 3A. An IP must disclose, must, look at the word must. Look at the word must. The word is not shall. Shall means applicable for living and non-living. But must is applicable for the living person. And the IP must disclose the details of any conflict of interest to the stakeholders whenever he comes across such conflict during an assignment. Please look at this. So he must disclose the conflict of interest. No. I am a related party. I am already a consultant to this particular creditor. So you disclose it. So after disclosure, if people are willing to retain you, okay. Because that can be a point of litigation later. So better to actually, and this is a code of conduct. And if you don't disclose, you're violating the code of conduct. And that can be a reason for taking a disciplinary action by the board, by the IPA. Very, very sensitive. I'm telling you, very, very sensitive. 23, come to 23, and they've inserted 23A, 23B, 23C, 23D. This entire 23 they have deleted, they inserted 23, 23A, 23B, 23C, and 23D. So 4 regulations there. 4 code they have inserted. This is with respect to occupation. An IP must not, that is must, it is must not engage in any employment when he holds a valid AFA or when he is undertaking an assignment. It only says you should not engage in employment. You should not practice chartered accountancy. You should not practice company secretary. You should not practice cost accounting. You cannot practice law. It doesn't say. Okay. Employment alone is not allowed. So an IP must not engage in employment when he holds a valid AFA or when he is undertaking an assignment. Okay. Most important. So no employment. 23A. When an IP has conducted a CIRP, he and his relatives shall not accept any employment other than the employment secured through open competitive recruitment with or under professional services other than services under a court to a creditor having more than 10% voting power, the successful resolution applicant, corporate debtor, or any of the related party for a period of 1 year has elapsed from the date of his cessation from such process. This 23A is a social distancing code. So for in Tamil, I used to say for 1 year, annan thanni padagave kuda. What do you mean by that? It means for next 1 year, you should not even when they invite also don't go there. Okay. So very important point. So creditor having 10% or more, social distancing. Successful resolution applicant, social distancing. The corporate debtor subject to CRP, social distancing. Any of the related party. You are already you were the RP, so you know who are the related parties. Now, related party as on, somebody would have become a related party later. Now, this particular point, related party at what point of time? That is the question. Sometime after you you have come out of that assignment, there will be a new related party. Can you can you do your any service to them? Okay, my view is so the moment they say 1 year, better to be off with their past and present related party. Okay, so this is subject to lot of interpretations. So you have to be very careful. Okay. Then 23B. An IP shall not engage or appoint any of his relatives or related parties in connection with any work relating to any of his assignment. Meaning, I am partner in a firm, they should not do any activity. Okay. So, I am my related, my blood relations. So, no, they should not be appointed. So, the only best option is networking. Networking is the only best option. And in the networking also, relatives are prohibited. So, that is why friendship. The what they in Tamil we used to say Mulga the ship friendship, meaning that ship will never sink like Titanic. Okay, so that is the only possibility. Networking. Okay, networking among professionals. 23C. An IP shall not provide any services with the assignment which is being undertaken by any of his relatives or so 23B and C. You will not appoint relatives, and when relatives are asking, shall not provide any services with the assignment which is being undertaken by his relative. Your relative is a insolvency provision, he has taken. Will you give to them? That also you should not do. So your work also you should not undertake. You should not ask your relative to do. If your relative is an IP and you want to give any service, that also you should not. And related party is as per the Insolvency Bankruptcy Code 23, related party as per 524A. 524 is related party in relation to corporate. 524A is related party in relation to an individual. Okay, 524 and 524A both are related party only. 524 is related party in relation to an entity, in relation to a corporate person. 524A, 524 capital A is related party in relation to an individual. So please understand the fundamental difference. Okay, good. So all these I have finished. I have mentioned now 23A of MBL. So this is your, I'll take you to the 23A, guys. Very interesting. This is introduced recently in the model bylaws. The AFA shall stand suspended upon initiation of disciplinary proceedings. See, when there is an order against him, he is not eligible. Proceedings are not eligible. Initiation, one notice is given, he is not eligible. Look at this, the sentences and all, very careful, very sensitive, I'm telling you. 24(2)(BA). 24(2)(BA). Cancellation or for authorization. The orders that may be passed by disciplinary committee. Okay, so DC can also give an order for expulsion, suspension, admonishment, imposition of penalty, or cancellation of AFA. That can also be one of the option in the disciplinary committee. Now come to 26. Good. Surrender of AFA. AFA can be surrendered? Yes. When you can do? Okay. At least 30 days before you can surrender. You become a person resident outside India. You take up employment. You start a business. So these are all the reasons where you can surrender your AFA. Okay. If surrender when it is not possible, the AFA has been suspended. The assignment is continuing. If there is a continuing assignment, you cannot surrender. Okay. You have to say at the time of surrender, is there any continuing assignment? No. Then only it will be surrendered. Okay. Very important. Okay. So then 12A to E and 9.7. I'm now going to compare. Okay. So so 12A to E. So let me take you to that. 12A to E. This is 12A to E. Has not attained the age of 70 years. I mentioned this particular point. Okay. But in information utility 9.7. This is information utility 9.7 IU. This is composition or governing board of an information utility. For your information, this NESL is the one and only information utility. Okay, so far. So now, look at this. An individual may serve as an independent director for a maximum period of 2 terms or 3 years or up to ages 75 years, whichever is earlier. So, in the information utility governing body, the independent director can be 75 years. In the insolvency professional agency, okay, governing board, that is 12A2AE. 12, this is here. This is with respect to the individual. Okay. But I want to take you to 5.8. This is 5.8. Look at this. 5.8. Composition of governing board of the insolvency professional agency. So, insolvency professional agency governing board. For example, look at this. This is your triple IP ICI. This is triple IP ICI. This is your governing board. Okay. And this is your governing. And this governing board, Ashok Haldia, Rashmi Verma, Sanjay Mittal, Satish Kashinath, Nihar Jambusaria, Debashish Mitra, Durgesh Kabra, Hansraj Chugg, Rahul Madha. So these guys, they can be there for how many years? 75. Similarly, NESL. In NESL, also governing board is there, the board. This is the board. R. Gandhi, Nivedita Haran, Sadagopan, Prakash Chand, Natarajan Sundar, Anindya Banerjee, Dev Jyoti Ray Chaudhary. They can be there for 75. Okay. So triple IP ICAI governing board members, IU governing board members can be there for 75 years. But as an insolvency professional, you cannot be eligible for a AFA beyond 70. Okay, so that is what I want to mention here. Very, very important. Okay, so please understand the fundamental difference between this 75 and 70. Okay, good. So then I'll take you to in IP 10.1. This is your IP. I want to take you to regulation 10, sub-regulation 1. This is regulation 10. An IP, and this is IP I have to. So which is IP. This is IU, no? So this is IP. So IP. So in IP, I'll take you to 10.1. Okay. So regulation 10, sub-regulation 1. Surrender of AFA. So an insolvency professional agency shall inform the board when issues an AFA. So, and this is actually IP, no? IP regulations. Okay. So whenever AFA is issued to the IPA shall inform the board. So in the IP regulation, there is a mandate given for an IPA, and you have a similar provisions also reflected in the IPA regulations also. It should issue, when it issues or renew an AFA, suspend, revoke, accept, within 1 working days, they have to inform the board. 24 hours. Okay. The board shall take note of the information. Board means IBBA. Okay. Good. That is 10.1. Then 11.8 BA. This is 11.8 BA. So suspension or cancellation of AFA also, there can be a disciplinary proceeding. So wherever changes they have made in general body, okay, so the model code and model bylaws and the general body of the regulation, wherever they have made an amendment, similar amendment also they have inserted in the respect to IP regulations. So this is then 12.1 capital A. So 12.1 capital A is now IP entity. You want to form an IP entity which will be a registered partnership firm or a LLP. Okay, or it can even be a company. If its sole objective is to provide services to IP, you cannot have multiple objectives. So I will do consulting, I will do accounting, I will do this, that. No, they have deleted everything. You form an IP entity only to give sole objective to provide support services to insolvency professionals. So that is very important. Okay, good. So that is 12A. 13.2B proviso and 13.2C proviso. So 13.2B. Inform the board within 7 days when an individual ceases to be its director or partner in form of along with the fee of 2,000 rupees. My God. Okay. So this is with respect to information, insolvency professional agency, insolvency professional entity. And that entity has to inform the board when an individual ceases to be a director or partner by paying a fee of 2,000 rupees. Provided when an individual ceases to be a director or partner, as the case may be, from the date of commencement of IBBI and ending on 31st December, the IP entity shall inform the board within 30 days of its cessation. Okay. So this is the only exception given for 31st December 2020 because this amendment came. Okay. This amendment came on 11th October. This amendment came on 28th March 2020. Okay. So that is very important for you. So that also I have covered now. So 13.1, 13.2B proviso. Okay, good. Now come to 13.2C proviso. Inform the board within 7 days when an individual joins as a director. So when he ceases to be a director also, pay a fee of 2,000 rupees. When he joins the director also, you inform the board in form F along with paying 2,000 rupees. Okay. So this is 13.2B and 13.2C. Then come to IU 21 and 21A. This is IU 21, regulation 21. Good. Come to 21, guys. Information of default. So this entire 21 is new. Okay. Green, red, and yellow. Very important. Okay. Information of default. Now, you know what this NESL will do? Okay. NESL. What is the purpose of this NESL? Whenever a bank is giving loan, they have to upload the information. And whenever they receive the money, EMI, that also they'll upload the information. And periodically, they have to inform that this statement to the borrower, and borrower has to confirm through digital signature. Now, when he confirms, debtor confirms, the status will be green. Debtor does not respond means it will be yellow color, amber. If he says no, he doesn't confirm, it will be red color. So, if he confirms, this will be taken on record to court of law. Please understand this. Because I have uploaded the information, he has confirmed. Court of law, it will be in evidence. Because under the code itself, it is very clearly mentioned. I will show you the code itself. Please look at the code. This is your code. Look at this. In this code, very clearly, the section mentions you have to attach this is section number 7 or section number 9. I'll show you. This is your section number 7. Look at this. The record of default recorded with the information utility. This record of default is what is this section? Information of default. So red color, green color, and yellow color. Very important. Okay, this is a total change they have brought. The information utility shall expeditiously undertake the process of authentication and verification of the information as well. Authentication, verification. So who has to authenticate? The information will be uploaded by the creditor, financial creditor. It should be authenticated by the borrower. Verification, authentication, verification. So your login will be verified and authentication, all online. And every year they will be getting that confirmation list. So they will send at least 3 times confirmation. All these things are there. For shortage of time, I'm not doing this. Now 21A. Dissemination of public information announcement. An IU shall disseminate every public announcement it receives or has access to the data of its receipt to its registered users who are creditors of the corporate undergoing insolvency. Very important point. Meaning, whenever there is a public announcement, there is a public notice of CIRP or liquidation, somebody may not know. Whoever are registered with it, they have to disseminate this. Please, this company has gone for CIRP, company has gone for liquidation. Your money, please be careful. Go and make a claim. Who has to do? NESL. This is very, very important amendment they have brought, 21 and 21A. So, guys, thank you very much for your everyday morning presence. I'll just need 5 more minutes. Wish to hear from few of you, the participants. Kindly raise your hand. I'll unmute you, and maybe I'll request first Praveen P. Gali. We couldn't hear you for last 1 or 2 days. We'll hear from you today, and we'll also hear from Mr. L. Ramadas. I've unmuted Mr. Ramadas. I've also unmuted Chandrasekhar, and we'll also hear from one more person. Those who have not spoken so far, I'll unmute you. We'll also hear from Mr. R. Ramaswamy, and we'll hear from Rajkumar also. Okay. So, and Mr. Ghosh, Mr. Aninda Ghosh also I will unmute. Bala Venkata, I think you already spoken, but anyhow I'll unmute you. So let us hear from all these gentlemen, please. So first let us hear from Mr. Aninda Ghosh and Mr. Srikanth also I'll unmute. Mr. Ghosh, you can unmute your mic and you can share your thoughts. And let us also hear from Mr. Srikanth. Mr. V. N. Srikanth, also I'll unmute. Yes, can we hear from you, please? Go ahead. And we'll also hear from Mr. Bala Venkata. And Mukesh Ladda also has raised his hand. Let us hear from him. And Mr. Ramaswamy, I have already unmuted you. You can... yes, Mr. Ramaswamy. Let's hear from you. R. Ramaswamy. Good morning. Very good morning.
Good morning to everybody. This is Ramaswamy from Bangalore. I'm a 68-year-old chartered accountant and company secretary.
Sir, you are eligible for AFA.
So basically, as I informed Dr. Raju, I joined this more out of curiosity. And I'm not appearing for examination now, but then after attending this for the last 5 days, I'm now, I have now made up my mind and I'm 100% confident of joining this course. And whether I'm eligible or not, and even if the amendment doesn't take place, extending age from 70 to 75, because next year I'll be 70, doesn't matter.
Welcome.
Or as a challenge for my own self, I'm going to do this, and the interest was created purely after attending this session. Thanks to Dr. Raju and thanks to all the participants, and wishing everybody whoever is writing examination now and the next year all the best and bye-bye. Thank you.
Thank you. Thank you, Ramaswamy ji. And let us hear from Mr. V. N. Srikanth. Good morning, Mr. Srikanth.
Good morning, sir. Am I audible?
Absolutely clear and loud. Please go ahead.
Yeah, I am Srikanth. I am also a chartered accountant, and as Mr. Ramaswamy told, I am also a senior citizen aging around 61. And I am personally involved in one of the cases as a home buyer. So I am interested in attending the moment I saw your email. Really, it's a great pleasure to attend your class, and I got enlightened really. Okay, and really, so far I was having the plan. Now I'm decided to go against it. If not this session, at least March 22, whatever may be the sections, whatever may be the amendment, doesn't matter. I decided to go. Whether I get it or not, that's a different issue. But one thing I am sure to say, sorry to take more time. You have explained it very lucidly, which I don't think anybody. I know it's created, and I started reading the books now. Really, it's a great pleasure, and congratulations for your Silver Jubilee celebration. And with this, you are doing a yoga. I mean, you are doing a great social service of free service to all the students. Although people can afford to pay, still you are making it free and every morning. Today also a busy day for you, Monday, and still you make 1 hour every day, and it is really, if I don't attend, that's a mistake. It's my loss, not to you. Thank you very much, sir. Thank you so much.
So nice of you, Srikanth. So nice. Thank you very much. And let us hear from Mr. Ghosh. Good morning, Mr. Ghosh. You can speak now.
Good morning, sir. Sir, I wanted to either what book should I, because what is happening, you are giving a very great lecture, and but as yesterday also some lady said, it is very difficult to follow at this juncture because we are busy in the office work, and so to concentrate on the studies is quite difficult. So which study materials we should study to get into the depth of the subject?
Sir, you have to only download all these rules, regulation, and start reading word by word first. So there is no guidebook and all. This is the code and the rules, regulation first we must read. So that is the only book. Now let us hear from Mr. Bala Venkata. Very good morning, Mr. Bala Venkata. I have just unmuted you. Let us hear from you, please. Good morning.
Good morning, sir. Actually, I didn't realize that 1st March onwards the syllabus would be different. I was thinking that whatever I'm, hearing from this conversation is for March. Sir, if you could, because I couldn't attend on the day one. Could you help us that the syllabus part, because I wanted to write in next 28 days. Just one small help. I was under the impression of 1st March, this is the syllabus.
Okay, our best wishes to you, Mr. Bala Venkata.
Thank you, sir.
Thank you. Now let's hear from Mr. Kaushik Shah. Kaushik Shah, good morning. I have just unmuted you. You can share your thoughts. And maybe if I missed anybody else, I'll just, I think that's it. Okay, we'll now hear back from Mr. Sampath Kumarji for your closing remarks.
Morning, Dr. Raju and my dear friends. These 5 days feast will make, as vouched by the senior members, the kindling of the feeling and making many of them who are not interested or having plans, they have decided to join the course come what may. And the pointed comparison between IU, IPA and other regulation or model code. When you read in a comparative study, the depth goes in. So that is very, very important for examination and for practice also. The compliances are very, very important and very relevant in practice area or whatever. So thank you very much, Dr. Raju. And Raju used to tell very repeatedly one point, take the printout, have the hard copy, go through. That is the fundamental. I have repeated, I have followed it, and I cleared the examination due to the fascination for the subject. And to refresh myself, I joined. I request each one of you to add a few lines before downloading the materials or whatever that. Dr. Raju, I am eager to join the Pinnacle course also in spite of heard you on the topics earlier. Every time I heard it is like a fresh, it is kindles the memory already that has gone in. Thank you very much. Thank you, my dear friends.
Thank you. Thank you, sir. Thank you.